You know, there's this invisible legal web that connects all of us. It's a fundamental obligation we have to just not harm other people. It's called the duty of care, and it is the absolute foundation of the law of negligence. So, how does it actually work? Let's get into it. It all really boils down to this one question, right? If someone's carelessness causes you harm, how does the law decide who's on the hook for it? Well, it turns out there's a process, and the very first, most important hurdle is proving that the careless person actually owed you a duty of care in the first place. Okay, so what is this duty we're talking about? This isn't just some moral suggestion like being a good person. Oh no, this is a very real, concrete, legal concept. At its heart, it's a legal requirement to act in a way that doesn't hurt others. And here's the really wild part. This duty doesn't just pop up because you signed a contract. It's a general obligation we all have to one another, just for being part of society. It's basically the law's minimum expectation for how we should all behave. And the story of how we even got this modern idea of a duty of care begins, believe it or not, with a snail in a bottle of ginger beer. This is the case that literally changed everything. So picture this. It's 1928, Paisley, Scotland. A woman, Mrs. May Donahue, is hanging out at a cafe. Her friend decides to treat her to an ice cream float made with ginger beer. Just a totally normal, pleasant afternoon. She drinks some of it, but when her friend pours out the rest, something absolutely disgusting plops out into her glass. The decomposed remains of a snail. Yep. As you can imagine, Mrs. Donahue gets really, really sick later on. But here's the detail that makes this case so fascinating. The ginger beer bottle was made of dark, opaque glass. Nobody could see inside it. That means the shopkeeper wasn't being careless. And of course, Mrs. Donahue had no way of knowing what was lurking in there. And this created a huge legal puzzle. She couldn't sue the cafe owner because her friend was the one who actually bought the drink, so Mrs. Donahue had no contract with the shop. And she definitely had no relationship with the manufacturer, who could be hundreds of miles away. So was anyone legally responsible here? Or was she just out of luck? The case went all the way to the highest court in the land, where a judge named Lord Atkin came up with an absolutely revolutionary solution. He introduced what we now call the neighbor principle. This single sentence pretty much created the general duty that we all have to one another. So who is our neighbor in a legal sense? Well, Lord Atkin's definition was incredibly broad and, frankly, brilliant. It's not just the person living next door. It's anyone you can reasonably predict will be affected by what you do. So, the ginger beer manufacturer, they absolutely should have been thinking about the final person drinking their product, people like Mrs. Donahue, when they were bottling it. And, just like that, the modern duty of care was born. But, of course, the law rarely just stands still. Lord Atkin's amazing principle was really just the beginning. Over the next century, as you can see, the courts kept working on it, trying to shape this broad, powerful idea into a more structured and predictable legal test. So the first big attempt to really formalize that neighbor principle came along in the late 1970s. This gave us the Ann's v. Merton case, which created a two-step test. Step one was pretty straightforward. Was there enough of a close relationship or proximity that you could see someone might get hurt? If yes, then the law would just assume a duty of care existed. Then, and only then, would the court move to step two and ask, are there any big-picture policy reasons why we should cancel that duty? Now, the problem with this was that it kind of opened the floodgates. By basically starting with, yes, there's a duty, and then working backwards, courts felt it was way too broad. They got worried that this could make people legally liable for pretty much anything and everything. The test needed to be tightened up. And that brings us to the modern standard that courts use today, especially when they're faced with a completely new or unique type of case they've never seen before. This is the Caparo test, and it's really the cornerstone for deciding duty of care in novel situations. It breaks the question down into three parts. It keeps those key ideas of foreseeability and proximity from before, but it adds a really powerful third element. Is it fair, just, and reasonable to impose a duty? That last part is so important. It acts as a crucial break and gives judges a ton of discretion. So if you look at them side by side, you can really see the change in thinking. The Ann's test was broad. It assumed a duty existed and then used policy to try and limit it. The Caparo test is way more cautious.
It's a three-stage balancing act where the court uses that fair, just, and reasonable idea to positively justify why a new duty should be created in the first place.
So you might be thinking, okay, does this mean courts are running through that three-part Capra test every single time a negligence case comes up? Well, actually, not quite. The most recent updates to this have added another layer of good old common sense. Yeah, in 2018, a case called Robinson really cleared things up. The Supreme Court basically said, look, that three-part Caparo test shouldn't be used for every single case. Its real job is for situations the law has genuinely never seen before, truly novel cases. So today, the courts take a much more cautious, step-by-step approach. The first thing they always ask is, have we seen this before? Is there already a clear precedent? Think about obvious duties, like a doctor's duty to a patient. If there's no direct precedent, then they try to find a close comparison, an analogy to a situation where a duty is already known to exist. It's only if a case is completely new, with no precedent and no good analogy, that they finally bring out the full three-part Caparo test as a kind of last resort. So, let's bring it all together. The duty of care is that fundamental legal obligation to look out for your neighbors, which is anyone you might foreseeably harm. This whole idea was born from a snail in a bottle. It was shaped by Lord Atkin's simple but powerful principle, and now it's evolved into this careful, step-by-step process where courts build on the past before they ever create a new duty from scratch. And that leaves us with a pretty fascinating question for a modern world. I mean, Lord Atkin came up with the neighbor principle in the age of the steam engine. But in a world of self-driving cars and artificial intelligence, who is our neighbor now? Who should the programmer of an AI algorithm reasonably have in their mind? The law is still grappling with these massive questions, applying the very same principles born from a snail on a bottle to challenges we're only just beginning to imagine.